Good morning. Welcome back to Debt Resolution Fridays. My name is Jen Koss, and I'm one of our bankruptcy attorneys here at Robinson & Henry, along with my colleague Liz Domenico. We've got some great questions that you guys have asked about bankruptcy, so I'm going to take some time today to answer those for you. Please also be sure to submit your questions if you have any, and we'll be sure to answer them either today or next Friday. You can also look at past weekly videos in our archives that Liz has done to see what other bankruptcy questions have been answered, and yours might be there. We're here as a reminder every Friday at 11 a.m. to answer your questions. And also remember that we do offer free 30-minute consultations here at Robinson & Henry with both myself and Liz. And you can schedule those free consultations on our website at www.robinsonandhenry.com, or you can call 303-688-0944. Alrighty, let's go right ahead and jump into these questions that we received for this week's video. First question, I received disability benefits from the VA. Will my bankruptcy affect my benefits? First, filing a bankruptcy should not stop or harm your VA benefits. Actually, thanks to the Haven Act, VA disability benefits are actually not even counted as income anymore when determining Chapter 7 eligibility in a bankruptcy. They're now being treated similarly to Social Security benefits in this way. And this is because in a Chapter 7 bankruptcy, first and foremost, you need to qualify based upon income. So this is great news. We've been able to have more clients qualify for the Chapter 7 bankruptcy because of the Haven Act. I actually recently had a client, two clients, they were married, and they were looking to file a joint Chapter 7 bankruptcy. One spouse was a W-2 wage earner, and the other spouse received VA disability income. Without the Haven Act, they would have made too much money to qualify for the Chapter 7. But now with the Haven Act, we were able to file a Chapter 7 and they were able to qualify, which ultimately was a more inexpensive and quicker process for them. So that was great for them. All right, second question. I read that some people may be able to get back payments that they made to creditors if they file for bankruptcy. Can you tell me more about the so-called clawback payments? So first and foremost, when you file your bankruptcy, we have to disclose any payments to creditors over the amount of $600 in the 90 days prior to your bankruptcy filing. Provide this information because the trustee can actually go back to these creditors, usually unsecured creditors, and collect its paid over $600 in the 90 days prior to filing money, and then disperse it to the other creditors in your bankruptcy, which means that money could get paid to a taxing authority, medical, etc. And similar, this is important, this comes up quite often, people ask about this. Similarly, a trustee can do that were made family members prior to friends and family insiders that get preferential treatment, you, the debtor. Generally, the court knows that you would perhaps borrowed money from a friend, family member, and then actually pay them back in the last year. I recently had a client who had borrowed about $5,000 from his father and actually paid back all $5,000 about 10 months ago. So we were able strategically on the timing of his bankruptcy to make sure he was held 12-month window before filing the bankruptcy so that the father would not get sued by the trustee to get back that $5,000. All right, next question. If you took out a private student loan to help pay for college, can this debt be included in your bankruptcy? It was not a federal loan. All right, so first and foremost, when you file a bankruptcy, any and all debt that you have on the date of filing is listed in your bankruptcy. We don't get to pick and choose what debts are listed, but that doesn't mean that all debts that do get listed get discharged. Federal and private student loans both are usually, unfortunately, non-dischargeable. So we usually tell clients to prepare to be responsible for student loan debt still. There are very rare circumstances where you might be able to get student loan debt discharged. You would want to speak with a bankruptcy attorney that specializes specifically in that type of discharge. Also, I like to point out, because some people call us and say, hey, I'm being garnished for my student loans, how can I make it stop? Filing a bankruptcy will stop a student loan garnishment. So a bankruptcy could work with you strategically to do that and talk about what that might mean for other debts that you have, for your student loans and other assets moving forward. It's important to also note that student loans do go into forbearance when you file for bankruptcy, but interest is still accruing. All right, next question. How do creditors find out about the automatic stay of the bankruptcy? Do I have to call them? And how do they know that I filed a bankruptcy? So once you file a bankruptcy, just to back up a little bit, if you're unfamiliar with what the automatic stay is, when you file a bankruptcy, you're protected under law by what's called the automatic stay. And that means that creditors cannot collect from you, they cannot garnish bank accounts and wages, they can't report on your credit or attempt to collect with harassing phone calls and emails and texts. Here at our firm, when you hire, we run your credit report and we'll directly import all of those debts on your credit report, which will include their mailing addresses for the creditors. And that'll go right into your bankruptcy under what's called your schedule of creditors. We also give you a copy of that credit report and say, hey, take a look at this, see if any debts are missing. So oftentimes medical bills or debts that you might owe to a friend or family member are often not on your credit report. So we'll ask you to either send us an old bill or just to tell us, what that debt is, and we'll manually add them to your list of creditors. If we need to look up a mailing address, we'll gladly do that as well. So we do as much as possible for you to make sure all of your creditors receive notice, because once your case is actually filed, the court is then going to mail out notice to all of your creditors. So your creditors are going to be alerted of your bankruptcy, and they're going to be alerted of the date, time, and location of your meeting of creditors, which I think we're going to chat about shortly. I saw a question about that later on. Additionally, if for some reason we file your case and there was a bad address for that creditor, or administratively it's just not catching up to them quick enough, that's when we as your bankruptcy attorneys can step in to help. We'll personally reach out to any creditor that's still contacting you after you file a bankruptcy and say, hey, here's a copy of their notice of filing. You need to stop contacting them because you're violating the automatic stay protection of the bankruptcy. So we're here to help you to make sure you're no longer harassed. All right, this next question has to do with COVID. I lost my job due to COVID-19. Can I still file a bankruptcy, or do I need income? So the short answer is yes. You can still file a bankruptcy if you don't have income. Income is only required in a Chapter 13 bankruptcy because you need to be able to demonstrate to the court that you can actually afford the monthly payment plan. However, in a Chapter 7 bankruptcy, no income is required. And there are, of course, other factors to consider when filing a bankruptcy, such as a Chapter 7, what assets you might own, what your income looked like in the previous 6 months, even if you're currently unemployed. Remember, it's a 6-month look back on income to determine eligibility for a Chapter 7 bankruptcy. So really the best way to determine if a Chapter 7 is best for you, especially if you've lost your job, is to speak with a bankruptcy attorney so that they can properly do a case evaluation. And sometimes it comes down to needing to be strategic as far as timing goes, waiting a certain number of months to get filed due to your income. And of course, we can help with being strategic with that. All right, next question. Do you still owe taxes if you file bankruptcy? Can back taxes be worked into your Chapter 13 payments? So it's often really difficult to get tax debt discharged in a bankruptcy. There are a lot of nuances. There's also a hard rule that any tax debt in the last 3 tax years is standard non-dischargeable. And whether or not your tax debt gets paid in a bankruptcy can depend on your chapter of bankruptcy that you have filed. Taxes in general are considered what they call a priority debt, meaning that they usually get paid first amongst your creditors if creditors are paid in your bankruptcy. So let's talk about both a 7 and a 13 scenario. So if you're a Chapter 7 case and you're what's called an asset case, that means that assets have been liquidated in your case, or you have paid money to the trustee to be able to keep unprotected assets, such as a firearm or an ATV, for example. And that money that's collected or assets that are liquidated and sold and proceeds are gathered by the trustee, that money could be paid to someone like your taxing authorities, because again, they're a priority creditor. Otherwise, in a Chapter 7 case, if you are a no asset case, meaning nothing has been liquidated and the trustee did not collect any money from you, or if he collected a very small amount, such as $250 for a firearm so that you could keep your firearm, that small amount or that little to no amount that might go to the IRS or the Department of Revenue, it could be applied to your back taxes, but likely if you have a significant amount of tax debt, you're still going to owe it then. Also, after you file a bankruptcy, a tax attorney can help contact the IRS or the Department of Revenue, wherever you had that tax debt, to see what tax debt, if any, still remains. And we have a great tax attorney here at our firm, Lucas Fry, who's fantastic, and he also does free consultations. All right, and also let's talk about the Chapter 13 scenario. So in most cases, your tax debt is going to be paid via your monthly bankruptcy payment plan in a Chapter 13 case. Again, taxing authorities are often the first creditor to get paid since they are considered a priority debt. However, certain portions of your tax debt could be considered priority while others are not. And that's something that we can help with as well, determining, so we know the treatment of your payment plans to the court. Because in a Chapter 13, the bankruptcy wraps everything up into a nice, easy monthly payment plan where the trustee then takes your payment and disperses that money to your creditors and does that work for you. All right, next question. Is there ever a time when someone does not qualify for some kind of bankruptcy, or do people always have some sort of option? All right, so most people qualify for at least a Chapter 7 or a 13. However, there could be a scenario that qualifies for one, but maybe it's not the best option for them in the present moment. So for example, if you're unemployed, like I talked about earlier, a Chapter 13 is not going to be an option for you because you can't demonstrate that you can afford a payment plan with the court. Now, what if that same person that's unemployed also has a house, but they have over 75 grand in equity in their home? Remember, you get up to 75 grand in equity in your home, or else you risk losing it in a Chapter 7. A Chapter 7 here is not ideal for them either because they could lose their home. So ultimately, it's rare that we find someone can't fit. Sometimes it's a matter of they might not ideally fit into either chapter of bankruptcy. So it could happen. Even then, we usually can be strategic in planning as far as timing and asset goes. It doesn't always mean it's in your best interest just because you do qualify for a bankruptcy. Again, that's something we can work with you on timing and asset planning. So there's a lot of different factors, and that's why it's important to chat with your bankruptcy attorney about why a certain chapter may or may not be a good option for you, or why right now versus maybe in 3 to 6 months might be better for you. We can provide asset planning advice. We can talk about how to spend down certain accounts or how to sell safely certain assets so that you don't find yourself in trouble with the bankruptcy court. Because ultimately it's our goal to minimize the impact, particularly negative impact on you in your case. All right, next question. I expect to receive some inheritance from my grandmother this year. How will a bankruptcy affect my inheritance, if at all? So inheritances can be tricky when it comes to bankruptcy. First, we have to disclose the receipt of any inheritance in your statement of financial affairs, which usually dates to the current year and the 2 preceding years. Inheritances like that are usually a one-off, so we generally don't want to include them in your 6-month look back on income. Again, this matters if you're trying to qualify for a Chapter 7 especially. However, there is a risk that the U.S. Trustee's Office argues that an inheritance should count in your last 6 months' income on that look back. So it is a risk. Again, this could be huge in a Chapter 7 case if it potentially disqualifies you on the 6-month look back. A bankruptcy attorney can also work with you to be strategic about the timing of your filing should you have gotten a recent inheritance. I also like to add when I talk about inheritances to clients that money in a bank account that is from an inheritance is not a protected asset. It doesn't get the 75% protection of a bank account like most do that hold your disposable earnings. So again, we can always chat with you to talk about how to strategically spend that money in a safe way, or if we want to play with the timing of your filing. Another thing I like to add to people who ask about inheritances is be prepared, even if you don't have that inheritance anymore, be prepared to explain how you spent any inheritance received in the last 2 years or so. Because the court is going to see that we listed in your statement of financial affairs that you received an inheritance. And they want to know how you spent that money because they're trying to make sure that money is not being hidden or that you didn't gift a friend or family member that money just before filing. Another thing to note is that you do have to disclose to the trustee any inheritances that you might get within 6 months of filing your case. So even if you don't get the inheritance at the time that you file your case, you still could be required to turn over that inheritance to the trustee. So again, keeping the communication between you and your attorney so that you can strategically plan your bankruptcy so that there are no surprises is really important. One more thing I like to add regarding inheritances. If you happen to be the beneficiary of a trust, you'll definitely want to speak with a bankruptcy attorney about the details of that trust because there are a lot of nuances that can impact a bankruptcy that are really fact specific when it comes to trust. So keep that in mind. All right, next question. Is there any way to keep your house if you file a Chapter 7 bankruptcy? Let's see, the short answer is yes. However, it depends on how much equity you have in your house or whether you're current on your mortgage. So here in Colorado, you can have up to 75 grand in equity in your house without risking losing that house in a Chapter 7. This is called the homestead exemption. There's also a heightened limit on the house equity for those over the age of 65 or if you're disabled. If you're filing a Chapter 7, you also want to keep in mind, if you have a house as well, that you want to be current on that mortgage. And this is important because if you file a Chapter 7 bankruptcy, even if the case is already filed, if you're behind on that mortgage, your lender is going to seek permission from the court to lift the automatic stay protection of the bankruptcy, which they can do with permission from the court to then foreclose on your house. So there's no catch up, and this is because there's no catch up in a Chapter 7 like there is in the Chapter 13. In a Chapter 7, there's no payment plan. In the Chapter 13, you can catch up on those missed mortgage payments through your payment plan. So super important to keep in mind if you're wanting to file a Chapter 7 bankruptcy that you're current on the mortgage. And a lot of people also ask me, well, how do I figure out how much equity I have in my house? You can figure out the equity by taking the fair market value of your house and subtracting your mortgage balance from that. First and second mortgage. That's going to give you your equity. As far as the fair market value of your house, a lot of people will use recent nearby comp house sales. Some people will use online tools such as Zillow or Realtor.com, but honestly, a lot of online sites tend to be all over the place. So some people do just go and obtain a formal appraisal. And a bankruptcy attorney can help you figure out if it's worth your time and money to pay for a formal appraisal on your house, especially if your equity might be borderline on that 75 grand. So we can definitely help with advising on that. All right, last question. How involved do I have to be in the bankruptcy process? For example, do I have to go to court or be part of a meeting of creditors? Yeah, so we get a lot of questions about what your role is as the client in the bankruptcy process. So let's chat a little bit about that. Here at Robinson and Henry, we do as much work as possible for you. In the document and information collection stage, since you're the only person with all of your personal information, we do work with you to obtain specifically requested documents and pieces of information. We'll, of course, like I mentioned previously, we'll run your credit report ourselves, and we'll, of course, send it to you to review for any missing debts. Like I mentioned, especially medical bills tend to not show up. So we'll work with you to make sure we get all of your debts listed. And then here at the firm, your attorneys, we're going to go through all of your paperwork on our own. We're going to draft your case for you using that paperwork. If we have any questions while we're drafting or need to fill in any gaps, we'll reach out to you. But otherwise, we then at that point will move to your signing meeting, which usually takes about an hour or so, depending on the case. And at the signing meeting, we're going to work with you to make sure everything is 100% accurate, everything's as up to date as possible, and we're going to fill in any gaps that we might have in our drafting. So we're going to work together to make sure your case is as accurate and up to date as possible for your filing. And usually from there, about 4 to 5 weeks later is when you have this meeting of creditors, which is also sometimes called a 341 hearing. It is required by the court that you attend your one mandatory meeting of creditors. We, of course, as your attorney, will attend that with you. Right now, with COVID-19 going on, all of the hearings are actually telephonic. We'll, of course, be on the line with you. But to kind of sum up the hearing, because I know that a lot of people get nervous thinking about attending the hearing, and we always want to put your mind at ease about this process. It is a very quick and informal hearing. There is no judge at the hearing. However, you are under oath because you are testifying and answering questions on the record. So we don't want to undermine the importance of it, but we certainly don't want people to be overly nervous for this hearing. It is an opportunity at this hearing for your creditors to ask you questions if they want to, because again, remember, they're going to be mailed notice of your bankruptcy and of the meeting of creditors. They do have the opportunity to ask questions, but it is very rare, to be honest, that we see creditors attend one of those hearings. Here at Robinson and Henry, we'll fully prepare you for that meeting of creditors so that you know exactly what questions are going to be asked. We go to so many of these hearings every week so that we've learned over time exactly what questions are asked. And this allows us to meet with you prior to your hearing and fully prepare you for your hearing so that there are no surprises and your nerves are at rest. Additionally, a little more responsibility in the Chapter 13 bankruptcy. You're, of course, also responsible for ensuring that you are making your monthly payment plans over the course of your 3 to 5 year bankruptcy payment plan. We're very communicative here at our firm on our bankruptcy team, so we like to keep you informed every step of the way. After all, this is your case, and we do as much work for you as we can, only requesting your assistance when absolutely necessary. Alrighty, that is all the time that we have this week. If you have any bankruptcy questions that didn't get answered today, please do be sure to send those to us, and we'll get those answered next Friday, Friday at 11 a.m. As a reminder, we do offer free 30-minute consultations here at our firm. So please give us a call at 303-688-0944 or visit www.robinsonandhenry.com to schedule your free consultation to see whether bankruptcy is the right option for you or what chapter might be best for you given your personal information. Thanks for your questions. We look forward to hearing from you, and we will see